Well, just real quick, tell you a little bit about myself. First off, thanks for having me. I know it's Global Entrepreneurial Week, so it's good to be around entrepreneurs. I'm an entrepreneur myself. My name's Matt Tipton, and I have an outsourced HR company. We work with small, mid-sized companies on everything HR, and in its simplest form, that means compliance, employee issues, understanding what it means to have employees, the risk that goes into having employees, and we help our businesses understand that when they're small, when they're growing, and what's coming next. And you know, with the government and laws passing on an annual basis, there's a lot of moving parts, and it can be confusing for anybody. And that's our job. Our job is to kind of fill in the gaps, to help you know what you don't know. And today, that kind of brings us to our topic. So initially, I was brought here to talk about this Department of Labor rule that was about to go into play. I'm sure many of you have heard about it. It's been in the news, just as entrepreneurs. I'm sure somebody has sent you a newsletter, solicited you to let you know what's going on. It's been the talk in all the chambers that, hey, salaries are going up per the Department of Labor on January 1st. So I'm going to start my talk by telling you that on Friday of last week, I had a presentation prepared around specifically that. But on Friday of last week, a judge filed an injunction against that law, shooting it down. So that is officially not happening as of today. That doesn't mean something couldn't change tomorrow, but that's where we're at today, and it's always a moving target. So I've decided to pivot this talk, and I want to have a broader conversation on the classifications of employees. That's very important. Just because this new law is going to affect, and it's very important that I clarify that it's not a new law. The law has always existed. It's the Fair Labor Standards Act. It's enforced by the Department of Labor. The only thing that changed was within the law on the salary thresholds. Doesn't mean that a salary threshold doesn't exist, and I'm going to talk about that here in a second, because when we talk about liability with employees, misclassifying an employee or an independent contractor can be very costly to a business. Wage and hour laws with the Department of Labor or the IRS is just something you want to get right. That's the best way I can put that. Now, this is also important for me to tell you at this time that I'm an HR professional. What does that mean? Well, I can tell you what it doesn't mean. It means that I'm not a CPA. It also means that I'm not an attorney. So what I do in HR, and I've been doing this for about 20 years, advising companies, is what we're going to talk about today is how to understand classifications, what to look for, and where to pivot next. And when it comes to a final determination, if you're still unsure, we highly advise seeking legal counsel from an employment attorney, not your divorce attorney, from an employment law attorney, and your CPA as well. All right? So we'll be very clear about that. So let's jump in. Let's talk about just, you're an entrepreneur, maybe you don't have any employees, or any contractors, but you're ready to hire someone. So what does that look like? Well, are we hiring a contractor or are we hiring an employee? A lot of individuals, I would say most, so you're not on an island if you thought this, you would think to yourself, well, I get to decide. I just want to hire somebody and I'm going to pay them as a contractor, or I'm going to hire somebody, I just want to pay them as an employee. What we don't realize, what most don't, is that the government actually tells us if they're an employee or if they're a contractor. And if we get it wrong, there can be penalties that are involved in that. And it can really stunt your growth early on by not getting that right. So what does that look like? Well, as I mentioned, where this new overtime law was shot down, is not going into effect on January 1st. There was a law that got passed that did go into effect this year, and that was in March of this year. So the Department of Labor, who has never been involved to an extent on independent contractor status, came out with their own set of guidelines of what classifies an independent contractor versus an employee. That's new. Before it was always the IRS, and the IRS has a 3-factor test. The Department of Labor has a 6-factor test, and they both still exist. Okay, so you have to run both tests to see, okay, if I'm going to hire a contractor, do they pass the test to be a contractor? So I thought I would start there and say, well, what does that test look like? And I'll give you some examples of each of these criteria. And it's important to know that when you're talking about contractors, that it's not about absolutes. It's more of a majority wins type of scenario whenever you make that classification. But know that the burden of proof of why you made that decision and that classification is on you as the employer, okay? So there's a very nice, what they call commonly asked questions out on the Department of Labor's website. I'm happy to provide that information to anybody. It's there for you to access, but I realize you gotta go find it. I'm happy to provide it. I'm sure my information is probably tagged on this video, so just shoot me an email. I'll give you, and I will tag you in on that. But one of the very first commonly asked question as it relates to independent contractor classification says, well, what if I have somebody sign a contractor agreement? Doesn't that mean that they are a contractor? Very specifically put, the answer to that question is no. And the reason for that is because the government takes the approach that me, if I'm the person that's saying yes to you as a contractor, they just assume that I don't know. I don't know what I don't know. And so, if there was an audit to take place, they're not going to rely on the fact that I signed a contract. They're going to sit down and be like, what do you do for this company? And they will determine if I should have been classified as an employee. And if I was, then that goes back to what we started with, which is there are fines and penalties and corrections that need to be made, and especially when it comes to taxes, and that can get expensive. And so don't make the assumption just because you had somebody sign a contractor agreement that maybe you even had legal draw up for you in case you hired a contractor, doesn't make them a contractor. It's important that you go through the testing and make sure that's the case. So what does that test look like? Let's talk about it. There are 6 factors. The first factor that we're talking about is the opportunity for profit and loss depending on the skill. So what does that mean? Well, if I'm a contractor, you're contracting me to do a job. So whatever you're paying me, say you're paying me $5,000 to do a job as a contractor. The profit and loss is on me as the contractor if I'm going to make money on that job. It means I'm using my own tools, I'm using my own time. I know how much effort is going to go into this, and the return on that is either going to be a profit or loss on my balance sheet. So if the project goes sideways, it's my loss, not your loss. Does that make sense? So that would tilt the scales towards a contractor, okay? Number 2, investments by the worker and the potential employer. So a good example of a contractor, when we talk about investments, is I'm using my own equipment. You hire me to do a job, I hire a lawn crew to mow my lawn, they're bringing their lawn equipment. They're not using what I've got in the garage. Does that make sense? All right, that's an example of that. So if you are hiring somebody and you're going to pay them as a contractor, but yet you let them use your office space that they don't pay for, they're using your computer that they don't pay for, they're using your software that they don't pay for, now we're talking about an employee. Make sense? Yeah, there you go. Number 3, degree of permanence of the work relationship. Typically, somebody that's hired as a contractor is there to do a job. You know, this is not a ongoing, I hope that you never leave me type of relationship. This is, I need something done, I'm contracting somebody to do it, there's a start date, typically there's some sort of definitive end date. Now that's not always the case, and that's why this is not about absolutes, it's about majority. But typically a contractor has an end date. If you're hiring somebody and you're like, I want you here for the long haul, for the ride up over the next 5 years and where we go from there, we're probably talking about an employee. Keep that in mind. Number 4, the nature and degree of control. Really, control is really, that's the crux of all of this. And that also applies to the 3-factor test with the IRS. It's always about control. The idea behind hiring a contractor is you're paying for a result. And you're paying for that result to be done by a certain time frame. What happens between A and Z, you don't care, because you're paying for this. You're not controlling the environment in between of how I do what I do best as a contractor. I know that you're going to pay me for a deliverable that I plan on delivering. But if you start controlling, well, you need to be at the office from 8 to 5, and you need to be here for meetings, and you need to do this, and you got to check in on this, Again, now we're starting to lean back towards control, which would be more of an employee-based relationship. Number 5, extent to which the work performed is an integral part of the potential employer's business. The best way I could describe this to you is I'm in HR. If I'm hiring somebody to do HR for my HR business, they're most likely an employee. But if I'm hiring somebody to do social media for my HR business, social media is not the business that I'm in. Does that make sense? It's not the business that I'm in. Therefore, that's a really clear-cut example of I'm hiring a contractor. Now, that doesn't mean that you may grow to the size that you want to have in-house social media and hire an employee. That's fine. Like, you're allowed to do that. Government's never going to get upset if you hire somebody as an employee and pay payroll taxes. Never going to be upset about that. What they're going to get upset is that if here I am in the HR business, and I go and hire an HR professional to work within my HR business, and they're not another like sub-HR company. This is just an individual doing the exact same thing that my business does. And again, that's going to tilt back towards being an employee. And number 6, skill and initiative. This is really interesting. So skill and initiative kind of goes a little bit against the grain with what we just talked about when it comes to the business of what you're in. We see this a lot in construction. So let's say you're in the construction business and you're really good at this one thing, but you're not really good at welding. And even though welding is part of construction, you don't do enough of it to hire a welder full time, right? So there's a provision, that's why that 6 bullet points in there, that yes, welding is considered construction. That is part of the business that you're in, but it's not enough of your business that you need to hire somebody full time. So it makes sense to contract to a contract specific type of welder that probably does welding for you, and they're doing a specific job, right? So now we're going back to one of the earlier bullet points of you have a start date and an end date, right? And then they're going to go on to the next scene because you don't have that position within your company full time, and they're probably doing that same thing for multiple other construction companies that have that need. That's their business. Does that make sense? Yeah. So you have this 6-factor test. I just ran through all 6. Again, on that link, if you reach out to me, happy to give that to you. You could also Google it. I'm sure you can find it. But they also have their own examples out there and things to look for. Because the key is that we want to make sure we don't hire somebody as a contractor and therefore denying them rights as an employee. You can't ever go wrong hiring somebody as an employee, W-2. All right? That's always an option. But be real careful, and I'm just going to tell you, I mean, I'm in the outsourced HR business. I deal with startups all the time. This is a very, I would say, common talk for me to come and give because so often the default, because we're just so scared of taking that step into hiring a W-2 employee within our company because we hear all the horror stories of what that looks like, and we'll talk about those. So we just default to like, oh, I'll just hire him as a contractor. And we don't realize that not only do we have the IRS looking at us, but you also have the Department of Labor looking at you now as of March of this year. That's a big deal. That's a big deal.
So is the IRS's rules similar?
Yes, very similar. So they have a 3-factor test, and it is specific to control and what they're looking at. And they basically take the Department of Labor, I would say, their 6-factor test is just taking the IRS's regulations and breaking it out into 6 bullet points.
Gotcha.
Yeah. They pretty much look at behavioral control, financial control
Gotcha.
is what they're looking for. Exactly. So okay, so let's take it a step further. So now, let's say we ran the test, and if they're a contractor, great. Be sure you have a contract in place. Make sure you have a good contract in place that specifically says, hey, this is what you're going to get paid, and this is how you're going to get paid, this is what you get paid for, and make sure that that contractor is invoicing you, all right? Make sure you got a paper trail to where they're sending you an invoice, you've got a W-9 on file, you've got a contract on file, and you got a pay schedule on file, right? Those are the big 3, okay? Set that aside. So we ran the test, it's like, you know what? I'm hiring an employee. When we think of employees, a lot of times we just think of, okay, I'm gonna pay you this amount. And for an entrepreneur, especially and really just in business in general, a very easy default for us, because we like fixed cost. Who doesn't love fixed cost? It helps us on our balance sheet. Really what we're talking about is paying somebody on salary. That's the key word. That was the big deal with the overtime law that didn't get passed. The law's been in place for years. It didn't go away, all right? The salary provision didn't change. A lot of people are very familiar with the term minimum wage, right? A minimum hourly wage that the federal government has in place, and then there are certain states that have a higher minimum wage that we have to be aware of. What a lot of people don't realize is that if you have what's called exempt, all right, and what we're talking about is exempt and non-exempt, all right, that if somebody is classified as exempt, guess what? There's a minimum wage, and a lot of people don't know that that exists, all right? For our purposes, before July 1st of this year, the minimum wage, and I'm going to use round numbers, okay, I'm going to round everything up, was $36,000 a year. So when we say exempt, what we're saying is this person is exempt from overtime. Let me be very clear about that. Exempt from overtime, meaning regardless of how many hours this individual works, their paycheck doesn't change. They're paid on a salary. So if they work 60 hours a week, the paycheck looks exactly the same. If they work 20 hours in a week, the paycheck looks exactly the same. And there are specific laws in place that explain how that works, all right? So for an entrepreneur, you can imagine it is very attractive to put somebody on salary because you always know what that cost is going to be. But the government, because they're so much fun, they have regulations in place and says, you know what? You can only do that, which means you can only not pay somebody overtime. That's the key. Exempt means exempt from overtime. You can only legally not pay somebody overtime if they pass the test. And they came up with 5 exemptions of where somebody can be classified and exempt from overtime. And if they don't fit into these 5, then guess what? They get paid overtime. Overtime defined in the state of Oklahoma is based on a 7-day work week, 40 hours of work within those 7 days, okay? That would be considered regular time, and any hours worked over 40 would be considered overtime. The reason I said Oklahoma, that's because that's where I'm giving this talk from, and if you were in California and you're listening to this talk, your state has different regulations. And states will always have some sort of spin on this, and it's important to know which state that you're in. If you're curious what the laws are in your state related to this topic, again, my contact information is there. I'd be happy to visit with you. But I will say for the most part, almost every state, overtime is based on any time worked over 40 hours in a 7-day period, and you do have to have a set 7-day period. So whether that's Monday through Sunday, or Sunday through Saturday, or Friday through Thursday, you have to define it. It can't be a moving target because you don't want to pay somebody overtime. All right? So that's important to know. So where do we go from here? So kind of like the independent contractor versus employee conversation, the government, you can always pay somebody as an employee, and you're good. You can get in trouble if you misclassify them as a contractor. The same is true for exempt, non-exempt. You're never going to get in trouble for paying somebody more than what they should be paid as a non-exempt and paying them overtime. But you can get in trouble if you classify somebody as exempt on salary and the key word here is deny them overtime because they're not truly exempt. Does that make sense? Okay. So now, what are the exemptions? Let's talk about this. So the first part, the very first part of the exemptions is actually what the overtime law that everybody's talking about right now that got shot down. That's like step one. It's like if you don't pass go, don't collect $200. So there's no reason to have this conversation if you're not going to at least pay them the minimum salary. All right? Now, unlike contractor status, where it's kind of like majority wins, we're tipping the scales on those 6 factors. In the exempt, non-exempt world, it's absolutes. So it's a test, and we're going to run through the test, but it's absolute. So you're either all in or you're out. So if you don't meet the salary, there's no reason to have the rest of the conversation. If you meet the salary, then we still have to have the rest of the conversation. Make sense? Okay. So let's talk about what the salary is today. I'm going to round up $36,000. So if your employee doesn't make $36,000 a year, there's no reason to talk about the rest. On July of this year, that went up to $44,000. Again, I'm rounding up. It was actually $43,888, but $44,000. So as of July 1st, if your employee didn't make $44,000, there's no reason to have the rest of the conversation. And if they made less than that, then there were a lot of employers that had to decide, do I give them a raise up to that? Or, you know what? They don't really work overtime anyway. I'll just convert them to a non-exempt hourly employee and start tracking hours. And that's perfectly okay. That's what the government would tell you to do. That's what you should do. Because the idea of the law is that people should, they look at it as more people should be eligible for overtime. That's how they view the world. Even though we may not see it that way, that's what this is all about. On January 1st, that $44,000 number was going to go up to, we were moving into the $59,000. That's a big jump. $59,000, yeah. So this injunction that just got filed by this judge in Texas, okay, and what's taking place, there's some great articles out there. I highly recommend you go to a legal article, Ogletree Deacons, give them a shout out. They did a great opinion on this out of the Oklahoma City office, and I know there's many more that's out there, and some great employment law attorneys that have done this. But they gave a great explanation of, you know, an injunction was filed, therefore that 59,000 number is not gonna happen come January 1st, but it doesn't mean it can't be appealed, and if it gets appealed, then the appellate court of the Fifth Circuit will be the ones to hear that appeal, and if they rule in favor of the Department of Labor, then we're right back to where we would have been on Friday of last week. All right? So that's what's going on. So set that aside. Let's just deal with the facts that we have. So this $36,000 number that we're dealing with. So yay or nay, do they make it? If the answer is yes, let's go on to step 2. And what we're talking about is what we call the executive exemption. Here's bullet point number 2. The employee's primary duty must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. So not only do they need to make $36,000, but they actually need to be doing something of significance. This is not your office manager, which is one of the biggest misclassifications that we see as an HR firm, is that you have your right-hand person, your ride or die, that's your office manager, but they really don't manage your office, all right? They manage the things around the office, but they don't have something of significance that's going to impact the bottom line of your business, that's going to impact the profitability of your business. Does that make sense? Okay, but we're not done yet. So even if they pass that part of it, here's the third bullet point. Remember, we're talking absolutes, all right? So this is not majority wins. Third bullet point. The employee must customarily and regularly direct the work of at least 2 or more full-time employees or their equivalent. So if you don't have 3 people in your company, it's very clear that the one person that you hire is not going to pass this exemption because there's not 2 other people to manage, and I doubt they're managing you. Does that make sense? So you would not pass the executive exemption. But we're also not done yet. There's a 4th bullet point. So even if you make it past those 3, the 4th bullet point is that employee must have the authority to hire or fire other employees, or the employee's suggestions and recommendations as to hiring, firing, advancement, promotion, and any other change of status of other employees must be given that particular way. In other words, they have influence in your business, and significant influence. And so if you don't run the table on that entire set, then you're not going to pass the executive exemption. As I mentioned to you, there's 5 exemptions, so that one's just off the table. The second one's a lot shorter. It's the administrative exemption. So again, you got to meet the salary. We already talked about that. All right. So if they're not making 36, conversation over. Second bullet point: the employee's primary duty must be the performance of office or non-manual work. All right. Non-manual is important. Typically, laborers that aren't managing other laborers will never be exempt. all right? So think about a painter, think about, people that are in construction. Those types of positions, just that there's not an exemption that's created for them unless they're doing administrative or executive type work in addition to. Does that make sense? And we run into that a lot. We deal with a lot of like roofing companies and those types of things that are a client of ours. And the reality is, if I walk into a roofing business or a construction business and I look at, and I'm doing an audit, so this is just an internal audit that I would do as our firm, and I see that over 50% of the company is paid on salary, I don't need to really see much more to know that we have some misclassifications. It's just not real life, okay? Again, nothing is absolute in that scenario, but been doing this a long time. So these are just things that you kind of catch on to. Now, if I walked into a software development company and I have a lot of professionals that's what they do is at a desk and they're all very highly compensated because they're literally developing software, then yeah, there's a good chance that just about everybody in there, minus probably the office manager and a few other admins that are there, they're going to be exempt. It's just some things that you kind of get to know, but you shouldn't just make assumptions. Like, you need to look at the tests, and you may not have time to do that. That's why we're here, and that's why other resources exist to go to, as I mentioned out in the beginning. So again, an employee's primary duty must be the performance of office, non-manual work directly related to the management or general business operations of the employer or the employer's customers. And the employer's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. We're not going to go through this today, but the government, because that's what they do, they actually have their own definition of what it means to say exercise of discretion. They have their own definition of what it means to say independent judgment, and they have their own definition of matters of significance. So before you just run with what I just said, you need to read those three definitions. We're not going to do that as part of this presentation, but I'm happy to talk to anybody about that process. Okay? So that's exemption number 2. Exemption number 3 is the professional exemption. So when we talk about professionalism, we're talking about learned professionals or creative professionals. So to qualify for the learned professional, again, we've got our salary. Don't pass go, don't collect 200. Bullet point number 2, the employee's primary duty must be the performance of work requiring advanced knowledge. Defined as work is intellectual in character, and which includes work requiring the consistent exercise of discretion and judgment. Typically what we're talking about here, professors, teachers, CPAs is a good example. HR professionals is a good example. These are typically degrees, higher learning, those types of things that people go to school for. The third bullet point is exactly that. The advanced knowledge must be in a field of science or learning, okay? And the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. And I will say a lot of attorneys, they're going to fall into that group as well, regardless of how they bill and what that looks like. And I'm sure there's some that would say otherwise. But again, advanced learning is what we're talking about. You can't do advanced HR, not beginning HR, but you can't do advanced HR without continuing education credits and constant field of learning. Does that make sense? Okay. And so that's your professional exemption. That's the learned professional exemption. Within that is also the creative professional exemption. So again, salary, that stays the same. And the employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So again, they have definitions for each of those areas, but a good example, and I'll give you both sides of this. We have some companies, kind of like what we talked about earlier, maybe they're in the construction business and they decide they want to have social media done in-house. They don't want to hire a contractor to do social media. They're big enough, they want to have their own social media department, marketing department. Does that make sense? So they go hire somebody to do social. Creatively, if they have the freedom to create all the social, meaning the content, right? The design, everything that's going to go out there, that could potentially fall into the creative exemption for that professional. But if it's the employee that's just taking the content that gets put into the spreadsheet that gets sent out on social, right? There's nothing creative about that. That's not any different. We run into this a lot like a bookkeeper. We have a lot of people that try to classify bookkeepers as exempt. They're like, well, they're doing all this, work, and they're dealing with numbers and spreadsheets. Bookkeeping, and this is not, I deal with a lot of bookkeeping companies. I'll be very careful how I say this. But you don't need to take my word. You can go out, again, this is all out there. Bookkeepers, traditionally, if they're not managing other bookkeepers for that executive exemption, it's plug and play. But if you're a CPA and you're actually analyzing the data for me as a business owner and putting together a financial strategy, now we're talking about an exemption. Make sense? Okay. So you got to be real careful. And when we do these, that's why we go into a business. Typically, I could care less about your job titles, and so does the government. They don't care if your job. You can have everybody be a vice president. They do not care. When they do an audit, they're going to talk to that employee and they're going to say, "What do you do?" And then they're going to look at their test, and you're either going to pass or fail. And potentially, you may have to reclassify that employee, and you may owe up to 3 years worth of back pay and overtime. You never know. All right. Because that is part of the law too, through misclassification. Keep that in mind. So let's go into our next exemption. We're almost there. Is the computer employee exemption. So they created one specific for computer professionals, and it's a little bit different. So with the computer professionals, and I want to get too far in the weeds. So again, if this is your business, it might be best just to reach out to myself. Again, talk to an employment law attorney. They can help you navigate this exemption. You have two options. So you either pay them the minimum salary, and again, that's just step one. We'll get to the rest of the steps here in a second. Or you can pay them a flat rate, all right, of $27.63 an hour. And so what that means is that instead of paying them, you can't pay them below that, but you can pay them on an hourly rate and not pay them overtime. So if I worked 50 hours this week and you weren't paying me a salary, okay, you would pay me on an hourly, but you wouldn't pay me time and a half for those 10 hours over 40 hours. You would just continue to pay me the $27.63 an hour straight time. Does that make sense? All right. So you have two things to look at there for your computer employee exemption, but that's just step one. Step two, the employee must be employed as a computer systems analyst, a computer programmer, a software engineer, or other similarly skilled worker in the computer field, performing the duties as described below. And I'll go through each of these duties, but I want to be very clear, especially for our computer professionals listening. There's a lot of businesses out there that you have help desk centers. So these are people that are taking in tickets and doing quick troubleshooting. Somebody's computer doesn't work, software updates, this kind of stuff. Those types of positions are rarely considered exempt because they're not creating software. They're not any of that higher degree field of learning, even though it is a field of learning. But for the most part, it's very trade related. Okay. So typically desktop support is another way to say that, or just desk support. Those positions typically, and again, I'm not going to say absolute, so I'm on camera, but typically are going to be non-exempt. So here's some primary duty of computer employees. Number one, the application of systems analysis techniques and procedures, including consulting with users, determining hardware solutions, software, and system functional specifications, design, development, documentation, analysis, I think you get the picture, the design, documentation, testing, creation, or modification of computer programs, combination of aforementioned duties, the performance of which requires the same level of skills. So you kind of get the idea on that. All right, next exemption, and then we're almost there, outside sales. So now you can throw a lot of the things that I said out the window, because outside sales exemption is the only exemption that doesn't require a minimum salary threshold. All right? The outside sales exemption allows you to pay that individual however you want to pay them. So think about it, they go out and sell something, and for every, like commission, essentially. All right? But they're still a W-2 employee, which means you still have to take taxes out. All All right, so if you pay them a draw against commission, we see that a lot. As long as they're doing outside sales, you can do that. All right, but also keep in mind, outside sales is different than inside sales. So we kind of think about it like this. You have hunters and farmers in a business. Your hunters, you eat what you kill. You're constantly going out there bringing in new business, and you're getting paid off of that new business, right? So that becomes like your client base of what you do. Typically, farmers are more like account managers. Once that business is already in the door, they may sell to that client, but they're there to actually manage the client. And as the client has resources or they recognize that they need extra support, they may say, hey, you need to upgrade, you need to do these things. But that's inside sales based. That person is not going to meet this exemption. As an account manager, they might meet one of those other exemptions, but then you got to pay them a minimum salary and yada, 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 right? So that's the difference, and that's why the outside sales exemption does exist, and it's the only one that kind of lands right there. Lastly is highly compensated employees. So they decided to create this separate exemption that if you pay somebody at least this amount of money, pretty much regardless of what they do, but I'll read you how it reads. It says highly compensated employees performing office or non-manual work, we've said that a lot today, and paid a total annual compensation of $107,432 or more, all right, are exempt because they customarily and regularly perform at least one of the duties of an exempt executive, administrative executive, professional employee identified in the standard test for exemption. So basically what that means is if your employees fail the executive test, they fail the administrative test, and they fail the professional test, you could still potentially not pay them overtime as long as they pass one bullet point of that test and you pay them $107,000. Yeah, and by the way, that new OT rule that was going to go into place, that is not going into place now, I keep saying new, it's not new, they were just increasing that line item on the salary threshold. They also increased that. I don't know it offhand, but it was a significant increase as well. So I'm hoping that something here, maybe you learned something new. Too often as entrepreneurs, like I said, there's just this whole world that you don't know what you don't know, and I live in that world as well. That's why we also consult employment attorneys all the time as things are taking place, and I consult with my CPA. I mean, there are just so many things that are out there, and the biggest takeaway is that let's not the time to put head in the sand. You do what you do because you're good at it, but know that there are some responsibilities that come with that, that maybe that's just not what you went to school for, it's not your trade. And I always like to say that this is the foundation. If you want to build the one-story house on sand, go for it. But if you're really serious and you're looking to build that skyscraper, this is that foundation that you don't want to be, so far down the line, have your entire business model built around something that could crumble at the stroke of an audit. If the Department of Labor, were to knock on your door, have an issue with the IRS. And I know there's other pitfalls, but I will say misclassification is a big one. And again, I just want to put that out there. We're a resource for that. There are many other resources. Nothing is absolutes. And hopefully this has been beneficial. So again, my name's Matt Tipton. My company is YHR. That's WHYHR.guru, Guru. And you can also see the many other things that we do out there, because outside of compliance, we want to build a fun culture. And there are ways to do that. And certainly would love to have those conversations. So again, thank you, and have a good rest of your global entrepreneurial week.